A woman in Ohio sold her mother's house last spring. She didn't want to. She loved that house, but the nursing home was costing over $9,000 a month, and somebody at the facility told her the family had to spend down everything before Medicaid would pay a dime. So she sold it, cleared about $200,000, watched it disappear into monthly bills over the next 2 years. Here's the thing, she never had to sell that house. Not one bit of it. Under federal Medicaid rules, that home was very likely an exempt asset, meaning Medicaid was never allowed to count it in the first place. Nobody told her, and she is not rare. She's the norm. There are 5 categories of assets Medicaid cannot count against you when it decides whether you qualify for long-term care. 5. And in my experience, most families know exactly one of them, usually the wrong version of it, with a critical detail missing that gets them disqualified anyway. Now, I'm not going to just rattle them off at you, because the order matters here. Number 1 is the one everybody thinks they understand. By number 4, most people watching will be genuinely surprised. And number 5 is the one that protects the healthy spouse. That's the one families discover about 6 months too late, after the money is already gone. Then, at the end, I'm going to tell you the single most important thing about this entire list. It's a catch that applies to every one of these 5, and if you don't know it, you can do everything right while you're alive and still watch it all go to the state after you're gone. So stay with me to the end on this one. Grab a pen. This is the kind of thing families wish somebody had explained to them a year earlier. First, let's understand what we're up against, because the number is going to shock some of you. To qualify for long-term care, Medicaid in most states in 2026, a single applicant can have no more than $2,000 in countable assets. $2,000. That's it? A few states are higher. California and New York run different rules, but for most of the country, that's the line. If both spouses are applying, it's usually around $3,000 or $4,000. And what counts against that limit? Cash, checking, savings, CDs, stocks, bonds, mutual funds, a second vehicle, a vacation property, most non-retirement investment accounts, retirement accounts like IRAs and 401ks count in some states and are exempt in others. That one genuinely depends on where you live, so don't assume. Now here's why families panic. They add all that up, see a number way over $2,000, and conclude they have to burn through everything they own before Medicaid will help. And that panic is where the expensive mistakes get made. Selling the house, gifting money to the kids, which, by the way, triggers the 5-year look-back and a penalty period, so it usually makes things dramatically worse. Cashing out accounts and handing the proceeds to a facility that was never entitled to them. But that $2,000 limit only applies to countable assets. And there's a whole category the rules simply do not let them touch. Let's go through them. Number 1, the home. This is the one almost everybody has heard of, and it's true. Your primary residence is generally exempt from Medicaid's asset limit. But here's where families get hurt, because there are conditions, and if you miss one, that exemption evaporates. The home is automatically exempt, no questions, no equity limit, if any of these people live in it: your spouse, your child under 21, or your blind or permanently disabled child of any age. If none of those people live there, then 2 things have to be true. First, there's an equity limit. In 2026, that's generally $752,000 in most states, and up to $1,130,000 in the higher property value states. That's market value minus what you still owe. Under the limit, the home is protected. Second, and this is the piece nobody mentions, if you've moved into a facility, you generally need to file a written statement of intent to return home. That's a piece of paper, a written declaration that you intend to go back. It doesn't have to be medically likely, but in most states, if nobody files it, the home can flip from exempt to countable, and now you're the family selling the house. That woman in Ohio, nobody ever mentioned intent to return to her, so the house is number 1, and it's the one everybody half knows. Let's get to the ones they don't. Number 2, 1 vehicle, 1 automobile, of any value. Read that again. Any value, not a $10,000 cap, not a reasonable transportation test. The primary vehicle is exempt regardless of what it's worth. Now, a second car is countable. that one gets added to the pile, but the primary vehicle is protected, and families sell perfectly good cars every year for no reason at all. Number 3, household goods and personal effects, furniture, appliances, your washer and dryer, your bed, your dishes, your clothing, your wedding ring, all exempt. This one sounds small, and honestly, financially, it usually is. But I want you to hear what it means about how the system actually works, because families torture themselves over it. I have heard of people selling their furniture, because someone told them they had to spend down everything. Nobody is coming for your kitchen table. That is not what spend down means, and the anxiety around it causes real, unnecessary suffering. All right, now we get to the ones people genuinely don't know. Number 4, burial and funeral assets. This is where the surprises start, and this category has 3 separate pieces to it. Burial spaces, a plot, a crypt, an urn, a niche, the actual space where remains are placed. Exempt. And here's the part that gets people. Generally, regardless of value, there's no dollar cap on burial spaces the way there is on almost everything else in this system. An irrevocable funeral trust. This is a legal arrangement, usually set up through a licensed funeral director, where you prepay your funeral and burial costs, and, this is the key word, irrevocably give up the right to take that money back. Because you can't reclaim it, Medicaid stops treating it as your money. State caps vary quite a bit, and a few states allow more than others, so check yours. And note the word irrevocable is doing all the work. A payable on death account at your bank? Revocable. You can withdraw at any time, so Medicaid counts it. A revocable trust. Same problem. If you can take it back, it's yours and it counts. A revocable burial fund, generally up to $1,500, smaller, and it comes with a catch we're about to hit in number 5. Why does this category matter so much? Because it's one of the few legitimate ways to convert countable cash into an exempt asset without triggering the look-back. You're not giving money away, you're buying something you were going to need anyway. And the average American funeral in 2026 runs somewhere around $7,500 to $10,000. So this isn't a rounding error. It's real money, legally protected, for something your family will otherwise have to pay for out of pocket while they're grieving. Number 5, life insurance, but only certain kinds. Here's where it gets counterintuitive. Term life insurance is generally exempt regardless of face value. Why? Because term policies have no cash surrender value. There's nothing to cash out, so there's nothing for Medicaid to count. Whole life insurance is different, and this is where families get blindsided. Whole life builds cash value, which means it's countable, unless the total face value stays at or under $1,500. Above that threshold, the cash surrender value generally gets counted as a resource. So picture a woman who's been faithfully paying on a $25,000 whole life policy for 30 years. She thinks of it as a gift to her children. Medicaid looks at it and sees a countable asset sitting there in cash value. And remember that $1,500 revocable burial fund from number 4. Here's the catch I promised. The face value of your life insurance generally reduces that burial fund exemption dollar for dollar. So if you're carrying $1,500 or more in face value, that separate burial fund exemption is typically gone. These two categories talk to each other. Most people have no idea. Now, lastly, there is often a fix. In many cases, a whole life policy can be irrevocably assigned to a funeral home, which converts a countable asset into an exempt burial contract. That's a real, legal, well-worn planning move. But it has to be done correctly, and it has to be done in the right order, which is exactly why this is not a do-it-yourself project. Quick pause, because this is exactly the kind of thing families tell me they wish somebody had handed them in one place before the crisis. If you want everything explained in today's video in one easy place, check out the U.S. Senior Survival Playbook 2026. It covers Social Security, Medicare, taxes, Medicaid, pensions, important forms, deadlines, and more, all in plain English. Get your copy at robertretires.com. Links at the top of the description. Now, I said there was a 6th thing, and it's the one that protects the spouse who's still at home. Everything so far has been about the person who needs care. But there's another person in this story, and for a lot of you watching, they're sitting in the next room right now. When only one spouse needs nursing home care, the other one, Medicaid calls them the community spouse, is not required to go broke. Federal law protects them, and this protection has a name, the Community Spouse Resource Allowance, or CSRA. In 2026, the community spouse can keep somewhere between $32,532 and $162,660 in countable assets, depending on the state and the couple's finances. $162,000 on top of the house, the car, the household goods, and the burial arrangements. That is a completely different picture than spend down everything. Now, two things you have to understand about how this works. First, all of a married couple's countable assets are treated as jointly owned, no matter whose name is on the account. Moving money into your spouse's name alone does not shield it. That trick doesn't work, and people still try it. Second, the applying spouse still has to get their own countable assets down to that $2,000 figure. The CSRA protects the community spouse's share. It doesn't erase the limit for the person applying. But friends, the gap between what most families believe and what the law actually allows here is enormous. I have watched families spend $100,000 they were legally entitled to keep because nobody at the nursing home ever said the words Community Spouse Resource Allowance out loud. Nobody is obligated to tell you. You have to know to ask. Now, the thing I promised you at the beginning, the one that applies to every single item on this list. Exempt from the asset limit is not the same thing as protected from Medicaid. Those are two completely different questions governed by two completely different sets of rules, and almost everyone assumes they're one thing. Here's what I mean. Every state runs something called the Medicaid Estate Recovery Program, MERP. It's federally required. After a Medicaid recipient dies, the state attempts to recover what it spent on their long-term care from their estate. And what's usually the biggest thing left in the estate? The house. The same house that was exempt the entire time they were alive. Sit with that for a second. That home was protected from the asset limit. It never counted. They never had to sell it. Everything worked exactly as it should have. And then after death, the state can file a claim against it anyway. The rules that made it exempt while you were living are not the rules that protect it after you're gone. Some protections do exist. Recovery is generally deferred while a surviving spouse is alive, or a child under 21, or a blind or permanently disabled child of any age. Every state is required to offer hardship waivers, for example, when an heir has been living in the home, or when recovery would leave them needing public assistance themselves. States vary a lot here, and some are far more aggressive than others. Roughly half go after only probate assets, while a large number are what's called expanded recovery states that pursue assets outside probate too. There are also real planning strategies, irrevocable trusts, life estate deeds, the caregiver child exemption, and in a small handful of states, a ladybird deed. But almost all of them run into the 5-year look-back, which means they generally have to be in place 5 years or more before you apply. Set one up in a crisis, and you've likely created a penalty period instead of a protection, which is the whole point of this video. The best time to understand these rules is when nobody is sick yet. 6 steps. Write them down. 1. Sort your assets into 2 columns, countable and exempt, using this video as your guide. Just seeing it on paper changes how the whole situation feels. 2. Look up your own state. Every number I've given you today is a federal framework, and states set their own figures inside it. Asset limits, home equity limits, burial trust, caps, whether retirement accounts count. Your state is the one that governs you. 3. If someone is entering a facility, ask specifically about filing intent to return. Get it in writing. This is the single cheapest protection on this entire list, and it costs nothing. 4. Pull out every life insurance policy you own and look for 2 things. Is it term or whole? And what's the face value? That determines everything about how it's treated. 5. If you're married, say the words Community Spouse Resource Allowance to whoever is handling the application and make them tell you the number for your state. Do not accept spend down everything as an answer. 6. If long-term care is anywhere on the horizon, even 5 or 10 years out, talk to a certified Medicaid planner or an elder law attorney in your state. I'm going to be blunt. This is one area of retirement where do-it-yourself genuinely costs families more than the professional would have. The look-back rule punishes late moves, and a strategy that works in Florida can be worthless in Ohio. Let me take you back to that woman and her mother's house. Her mother had a spouse who had passed. No minor or disabled children. The home was worth about $200,000, nowhere near the equity limit. Her mother was in a facility. That home was almost certainly exempt. She sold an exempt asset and spent the proceeds on care that Medicaid would very likely have covered because a well-meaning person at a facility used the phrase, "spend down everything," and nobody in the family knew there was a difference between everything and countable. Now, here's the part that makes it complicated, and I'm going to be straight with you rather than sell you a fairy tale. Even if she'd kept the house, estate recovery might have come for some of it after her mother died. She may not have kept every dollar, but there is a real difference between the state filing a claim against an estate, where hardship waivers exist, where deferrals exist, where a lawyer can negotiate, and a daughter voluntarily liquidating the family home in month 1 because nobody explained the rules to her. She had options. She never knew she had options. That's the whole tragedy, and it's completely preventable. So here's the question I want you to ask this week, and I mean actually ask it out loud to whoever handles this in your family. Which of the things we own are countable and which are exempt? And has anyone actually checked, or are we just assuming? Because friends, in almost every case I've seen, the family owned more protected assets than they realized and gave up things the law said they could keep. Not because they were careless, because nobody ever told them, and because the moment you're forced to learn, this is the worst possible moment to be learning anything. If this helped you, do 3 things for me. Hit that like button so more families see it before they're in a crisis. Subscribe so you don't miss the next one. And in the comments, type the word exempt if you want a full video on the 5-year look back and how families accidentally trigger a penalty period. And if you want all of it, Social Security, Medicare, taxes, Medicaid, pensions, the forms, and the deadlines, in one plain English place, grab the U.S. Senior Survival Playbook 2026 at robertretires.com. Take care of each other, and I'll see you in the next one.